Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On the 10th of March 2025, the state of Idaho filed a week early their response to the defendant's motion in limine number 11 regarding excluding IGG evidence. Now, I say a week early because the schedule for the briefings on the motions in limine set by Judge Hippler's court order was as follows. The motions were to be filed by February 24th, 2025. The responses were to be filed March 17th, 2025, and the replies to the responses were to be filed by March 24th, 2025. So in responding here to the defense's motion in limine regarding excluding IGG evidence that the defense filed on the 24th of February 2025, the state is a full week early. That is very rare in this case, that when there's a filing that's imposed by a deadline, that it's filed so early. This is one of the rare, maybe the only time I've ever seen this in reviewing all of the documents going back to the affidavit of probable cause of the 29th of December 2022, which was document number 1 in the case file. What is the state saying here, responding to the defense's motion in limine number 11? Well, they begin by saying, as they always do, as the parties do, they're coming before the court by and through their attorneys. In this case, it's the Latah County prosecuting attorneys. They are lead prosecutors in the case, even though the case was transferred, as you know, last fall, 2024, from Latah to Ada County because the crimes occurred in Latah County. So they have remained lead counsel for the state of Idaho, assisted by others, but it is Latah County. They're coming before the court on behalf of the state by and through Latah County prosecuting attorneys and respond to the defendant's motion in limine. This is number 11, ladies and gentlemen, regarding investigative genetic genealogy. That's the IGG DNA. This is a topic that has been so hotly contested throughout this entire case. It may be arguably the most hotly contested issue, other than was Mr. Kohberger guilty or not. In any event, they go on to say here, the defense's motion rests on an inaccurate factual assertion and an erroneous legal standard. So they're taking issue with both the facts of this case as articulated by the defense and also the law. The facts as applied to the law. They're saying they got it both, Judge, in both arenas. They got it wrong. Goes on to say, nevertheless, the state does not object to and has in fact also moved for the exclusion of the IGG information at trial. This is going to be a rare time that the state and the defense are on the same side saying the IGG evidence should be excluded from trial. They have butted heads on so many issues in the more than 2 years since this case has been pending. This is one area that they agree on, but they reach it in different ways. And the defense, you'll recall from our last episode of this podcast series on Idaho versus Kohberger, was asking for sanctions to be imposed against the state for bad faith conduct. If you have not yet had an opportunity to listen to that episode of the Indie Zone podcast where we presented a deep dive into the defense's position, please do so. It'll help make what the state is saying here more clear. In June 2023, the facts according to the state are as follows. The state moved for, quote, an order protecting the information related to the use, and we go on to page 2, of IGG in this case, end quote, including, quote, raw data related to the SMP profile and the underlying laboratory documentation related to the development of the profile, such as chain of custody forms. Very important, ladies and gentlemen, when you're dealing with evidence, chain of custody. How does the sheath, which is where this DNA was extracted from according to the state, how did it move from the crime scene, which the affidavit of probable cause said it was, in Madison Mogen's bedroom, and in fact on the bed where Maddie and Kaylee were? How did it go from Madison's room outside the house into however it was transported from there to get to the Idaho State Police laboratory in another part of Idaho in Meridian, and then from there go to Texas, where it traveled to go to Othram, as we've learned in prior episodes of the Indie Zone podcast, including during our presentation of the defense's motion in limine. Every step of the way, there has to be an explanation for the chain of custody, how it got from point A to point B to point C to point D, and so on. So they're saying here, such as chain of custody forms, laboratory standard operating procedures, analyst notes, etc. End quote. And they cite to motion for protective order, page 7, filed June 16th, 2023. And when we addressed the motion in limine number 11, the defense had asked for this discovery, asked for this IGG evidence in discovery. The state opposed. They had to go to a hearing, and in between the state saying here, and by the way, we filed a motion for a protective order, and we did so on June 16th, 2023. And here, Judge Stephen Hippler is where you can find this quotation. The state argued the IGG information did not fall within Rule 16 of the Idaho Criminal Rules because it was used only as a tip, and the state, quote, has no plans to present the IGG information for which a protective order is sought as evidence at trial, end of quote, other than having an investigator testify, quote, only that they received a tip pointing law enforcement to defend it, end of quote. And then the symbol id, this is referring back to the state's motion for protective order we've discussed earlier, page 7, filed June 16th, 2023. At pages 12 to 13, they're citing to specifically here. The state suggested that the court review the IGG information in camera to determine what, if any, of the IGG information should be disclosed to the defense. And then they go back it again to the motion for protective order filed June 16th, 2023, this time citing to pages 17 and 18. So what they're doing here is they're pointing the court to where, with specificity, Judge Hippler could find this information in the record to the exact page. And when we're talking about the court here, because this happened in 2023, this was prior to change of venue, so this was not before Judge Hippler. He's got to look at the record from the preceding judge. All of these things happened before Judge John Judge, who was the district court judge overseeing the case in Latah County just prior to change of venue. Then it says, the court, it says the court here, that means Judge John Judge, ladies and gentlemen. The court found, quote, state's argument that the IGG investigation is wholly irrelevant since it was not used in obtaining any warrants and will not be used at trial is well supported, end of quote. Order addressing IGG DNA and order for in-camera review, the in-camera order. Page number 30, filed October 25th, 2023. And ladies and gentlemen, if you've not yet had an opportunity to read that order rendered by Judge John Judge, it provided so much information, so many details, which up until that point was under seal. And that order is very lengthy, so it's probably going to take a couple of sittings to go through, but it really puts some background into the case as the court found the facts to be, and then ultimately rendered a ruling. It is dated October 25th, 2023, and on page 1, right away within the first paragraph, Judge John Judge explained that it was the feds who informed local law enforcement look at Brian C. Kohberger, because what we've learned, beginning with that court order and through when recent materials hit the docket, and specifically the transcript to the hearings on the motions to suppress evidence, the closed hearing, we learned that, in fact, the Moscow Police Department, this came directly from the lead detective, Brett Payne, who filed the aforementioned affidavit of probable cause, that they were not looking at Mr. Kohberger before they received a quote-unquote tip from the feds. What I continue to not understand is how is that information not relevant if there was, if they would have probably never even thought to investigate Mr. Kohberger up to and including today without that tip. Perhaps they could have arrived at him in other ways, but it was certainly that tip that's been confirmed by Judge, by Detective Payne, admitted by both, that came from that tip. And that happened December 19th, 2022, and 10 days later, Mr. Kohberger was arrested. I give my opinion here, as I always do under the First Amendment to the United States Constitution, freedom of speech and of the press. In any event, this was Judge John Judge's findings. And he also determined the defense may be entitled to some of the IGG information, citing to this order of October 25th, 2023. And the court granted the state's request for an in-camera review of the IGG information. So what the state's also not saying here is this was on a motion to compel that was filed by the defense. And so the court agreed, basically, that some of this information was discoverable by the defense, which is what they're arguing in their motion in limine that this response is directed toward. Then it says the state gathered the IGG information from the ISP, the Idaho State Police Othram, which is the private lab who contracted with the Idaho State Police and the feds, and turned the information over to the court. The information provided to the court included original documents, as well as some descriptions of other IGG-related information that was available for further review if the court chose to do so. After the in-camera review, and again, an in-camera review is not a review with a camera, it is a review in chambers for the court's eyes only. The clerk doesn't get to see it, the defense doesn't get to see it, the public certainly didn't get to see it. That's what in-camera means. The judge needs to look at this sensitive information and make a ruling. And Judge John Judge did. He did make a ruling that some of it was discoverable and some was ordered to be turned over to the defense. And it goes on to say basically this. After the in-camera review, the court issued an order describing which pages of the IGG information had to be disclosed, citing to the sealed order for disclosure of IGG information and protected order, calling it the disclosure order here, filed December 29th, 2023. The state then provided the defense with the materials that the court ordered disclosed. Doesn't say here what date that happened. But in continuing on with this is the facts section of the filing. We go on now to page 3. The court's in-camera order and disclosure order made it clear that all IGG discovery was to be filtered through the court. Nevertheless, a few months later, the defense sent a supplemental discovery request to the state, requesting additional IGG information. This is defense 15th supplemental request for discovery, exhibit N as in Nancy, filed March 27th, 2024. And if you want to go and find that 15th supplemental request for discovery and see what exactly the defense asked, you're not going to have a lot of luck, because you're going to see a document that's called the 15th supplemental request for discovery, but what the defense asked for, just like everything that was responded to by the state in these supplemental discovery requests, were filed under seal. They have not yet been unsealed. So you're not going to be able to find this information on the court docket. So we're learning here, the state explained the basis of its objection was that the state had already provided the IGG information to the court. The court had already ordered what IGG information must be turned over. So basically what they're saying here is that the defense is seeking another bite of the apple. You're asking for according to the state, what you already were denied by Judge Hippler. That's what their argument is here. The court then there's a little bit more writing. There's some citation to the record where judge stated at hearing, so Othram has said, you've asked them and they've said we've given you everything we have. The state responded yes. This is cited to the May 30th, 2024 transcript from hearing, page 85, lines 16 to 18. And then it goes on to say the court denied the defense's motion to compel as it related to, and we go on to page 4, the IGG information, and state cites to order on defendant's 4th and 5th motions to compel discovery, citing to pages 8 to 12 with specificity, filed June 14th, 2024, and then there's a footnote 1 here, very long footnote that consistent with this qualified hearing, the court's order gave the defense the benefit of the doubt and interpreted the request related to Othram to be asking for additional materials that were not already known to the court, rather than as an attempt to evade the court's protective order and secure from the state materials the court had already ruled on. And I'll let you read. It's a very, very long footnote here. It takes up more than a third of the page. So if you continue to read this filing, you're going to see the state basically beginning with their argument after they set forth the facts as they believe that they are. Page 6, the argument here is the defense's motion is based on a mischaracterization. Judge, they're saying the defense is misleading you, in other words, of the record and in opposite case law. So they're saying not only as they started off, the facts are wrong, and then they're applying incorrect case law here, saying the state did not act in bad faith. That's what the defense's motion is based on. That not only were Mr. Kohberger's constitutional rights violated, but the state acted in bad faith. The state did not act in bad faith, they say here. The state never made never made the concession the defense now claims, and the defense's reliance on Youngblood. That's a case cited in the moving motion. The motion in limine filed by the defense is legally erroneous. The defense has failed to both legally and factually cite to substantiate a Brady violation, which is what they're raising as well. And then they go into paragraph A, if you'd like to read it. It begins on page 6. The defense's motion is based on the wrong legal standard, and they set out what they believe the correct legal standard is, ladies and gentlemen, here. And then if you go on to page 8, the defense has not and cannot prove a Brady violation. That starts page 8, goes on to page 9. There's citations to the record and citations to legal authority. And it goes on for the next several pages. We go up to the conclusion, which is the bottom line, if you will. And this is signed by both William W. Thompson, the prosecuting attorney for Latah County, and also Jeff Nye, the Special Assistant Attorney General that has been assigned to assist Latah County in prosecuting this case against Mr. Kohberger on behalf of the state of Idaho. So that's rare when you have both attorneys here, but Jeff Nye was cited to specifically in the moving motion. That may be one of the reasons why he's also signing this. Usually just one attorney signs. Conclusion. The state did not act in bad faith, and the defense has failed to show the state violated its obligations under Brady. This court should deny the defense's motion to the extent the defense requests sanctions against the state. The parties do seem to agree, however, that the IGG information should not be presented at trial. This court should thus enter an order excluding the IGG information at trial other than as a generic tip for the purpose of helping the jury understand how the investigation progressed. Respectfully submitted this 10th day of March 2024. And because it was submitted early, the defense has 2 full weeks to prepare their reply, which I am almost guaranteeing you will be done. So we're going to keep our eyes out for when that reply to this response is filed by the defense, and we will report back to you in a future episode of the Indie Zone. For now, this is Kathy. Thanks for joining us here today.